Um, Good afternoon. It's a great pleasure to be back. I was here, was it last year?
Yes, last year. Different cohort, they've never seen me.
Yeah, so I'm hoping that you haven't already heard everything I'm going to say. So, as Professor Baumann was saying, I'm Lene Wendland. I'm heading the work, the chief, but that's not my choice of title. That's the UN nomenclature. Of the Business and Human Rights section in the Office of the UN High Commissioner for Human Rights. I've been doing that work for longer than I care to admit, but let's just say 20 years is probably just about right. Before that, I'm a human rights lawyer by background. I have never spent a day in the private sector in my life, so it's very much to my own surprise, and as for many others, that in fact I've dedicated the main part and the most important part of my career to working on business and human rights, including in relation to many companies and engagement with what it looks like inside of companies, because I'm really not the best one to talk about that, but I'm learning and have learned an incredible amount also from the work that we're doing with companies. So coming from a very traditional human rights background, I don't know exactly what your background is, but
business.
Good, because when young human rights people come and say, oh, we really want to work in business and human rights, my first advice is always go and work inside a company, because it's really there you have the potential to make the greatest change and learn the most and be closest to where the drivers of change will come. So I'm very pleased that that's what you will all be doing in your future. But when I give this kind of presentation, I often start with just talking about what are human rights before we get to the business part. And I use this slide because it has my favorite quote that I think is very relevant for the business and human rights, and I'll come to the quote in a minute. But you will see the logo here on the slide, Human Rights 75. It was actually last year. The UN had a year-long campaign celebrating the 75th anniversary of the Universal Declaration on Human Rights. How many of you are familiar with the UDHR, with the Universal Declaration?
It's the third session.
No, but just because
they have to now.
It's not about what you have studied, but whether you are familiar with it, that there is a text called the Universal Declaration.
Please don't let me down now.
Yeah, good, great. Because this is really the sort of the foundational constitution really for, I think my boss, the High Commissioner for Human Rights, he would probably say something like it's the foundational document for humanity, it's the constitution for humanity, how we want to treat each other as people in a way that ensures that everybody has the ability to live a life in dignity and with respect and not be discriminated against. And the Universal Declaration, it came about, as I said, 75 years ago, in 1948. And that timing, of course, was not incidental. It obviously built on 200 years, perhaps even longer, depending on how far back you go, on sort of thinking about the sort of relationship between people and the rights of man, as it was at the time. We would say now the rights of people. But 1948 was really the aftermath of the Second World War, where in modern times at least, as we would all be aware, I hope, the most grotesque and horrendous abuses of human rights had taken place. And so after the founding of the United Nations, there was this determination that the world should never see the kind of atrocities again, and the Universal Declaration on Human Rights was really the sort of foundational document that set out what are the rights and duties that every individual have, just because they are people, just because of not who they are, where they were born, what they look like, but really the inherent and inalienable right of people. So that was continues to be the cornerstone of the international human rights framework, the international human rights architecture. There are lots of human rights treaties and instruments that have come after the Universal Declaration, but they're all anchored in the Universal Declaration. That really is the foundational document, and I can actually recommend that you have a look. It's about 31 articles. They're all very short. It's not a long document, but it is so modern, I think, for lack of a better word. If you look at it, basically every single issue you see there are issues that we today are concerned about and are struggling with. Obviously, there are different ways now we think around the environment as a human rights and all these things, but the core fundamental issues that we all are concerned about, how we treat each other, privacy, freedom of expression, migration, the issue around asylum, right to a fair trial, right to an adequate standard of living, housing. I mean, all these things are things that are spelled down there, set down in the Universal Declaration. And as I said, when I was just doing a piece of work on it a few years ago, where I sort of read it every day, so I went back into it, and I actually couldn't believe how relevant and how current it was. Anyway, I just digress slightly, but the thing about the human rights system that's relevant for what we're going to be discussing is that human rights was meant to be put in limits mainly on states. And again, going back to the Second World War, it was states who were waging war. It was Germany, it was the other, Japan, Italy, Russia, the US, UK, it was the states that were fighting against each other, and again, from a historical perspective, the atrocities, for example, the genocide, the Holocaust was perpetrated by a state, Germany, against a group of people. And many of the other crimes, war crimes and others, were perpetrated by state actors against people. So the human rights response to that, the UDHR's response to that, was to essentially put limits on what states can do to people and what are the core obligations of state to ensure that people's rights are protected. So not just putting limits on how states can harm people, but also imposing duties on states on what they have to do to ensure that people are not harming each other, non-state actors, as it's called in the technical term, including companies, that they are not doing harm to people. So this quote, and I will now move on because Doro is thinking how we were getting there, is from Eleanor Roosevelt, who was the widow at the time of the US president, former US president, then deceased US president, who was one of the drafters of this declaration. And she had this quote, and it's not from the declaration itself, but it's so relevant, I think, to the business and human rights, is where after all do universal human rights begin? In small places close to home. So it has to live where we all have our daily lives, and then whether it's in the factory, the farm, the office, or in a university, in school, on the streets, it's all of us that have these rights. And if they have no relevance to us in our daily lives, then one can argue whether they have relevance at all. So it's really important to keep that in mind, that human rights is and should be living with us where we are in the interactions we have on a daily basis. It's not only for states. States might have the legal obligations, but that's a more technical thing. But the purpose of human rights is that we all feel that in our day-to-day lives we can be treated with respect. And I think that's a really important point when we're talking about business and human rights, because that's very much about how we as individuals, whether it's as members of communities, as consumers, or as online, as we are exercising our right to information and freedom of expression online, that the nexus between what we do as individuals and companies, it has to be relevant there, because if it's not relevant there, then I don't think any of us would be, or I certainly wouldn't be doing what I'm doing. So, long-winded introduction. But when we're talking about companies, so I said the human rights starts from the perspective that states are the ones who have duties and obligations with regard to human rights, and it's really mainly states that are the ones we're looking at from a human rights rights perspective, historically dating back to 1948. But companies, of course, can also have an impact on human rights. It's not only states that can do harm to people by putting them in prison and extrajudicial killings and denial of people's rights and discrimination and all the other examples we can think about. Companies can also have an impact on human rights, both positively and negatively. And again, I mean, I'm not the one to come. Business and human rights is not inherently an anti-business agenda. It's a full recognition that business can best do what they are there to do, which includes making positive contributions to society through job creation, paying of taxes. That should be certainly part of the picture. But that they can only fully realize their positive potential if they are not harming people in the process. So increasingly, in sort of dating back from 1948, and then if we're fast forwarding to the 60s, to the 70s, when there was a sort of move towards what we would now call globalization, there were outsourcing of production, there was more cross-border, transnational economic activity and financial flows, there was an increasing awareness that companies, as they were going about doing their business, actually could have negative impact on human rights. The pictures here, they are not necessarily representative for the full scale. That's obviously very much in the extractive context where many of these issues started to be discussed. You would have countries, let's say, these pictures obviously are from somewhere in Africa. Let's guess it's from Nigeria. And you would have a big European company, Shell, who was producing and getting oil from the areas of Nigeria where there's a lot of oil. And increasingly there was an awareness that the communities in which this oil was extracted were actually significantly impacted, and not in a good way, by the actions of this company. And from a traditional human rights perspective, you would say, well, that is the responsibility, that is the duty of the Nigerian government to ensure that when Shell is extracting oil, that they're doing it in a way that do not harm people. But as in this case and in many others, it became increasingly clear that governments were not always able or willing to do what they had to do in terms of protecting people's rights against activities. I mean, I'm not pointing fingers at Shell specifically, but against companies that would operate within their countries, but would maybe not adhere to standards that ensured that people were not actually harmed from what they were doing. So there was this increasing recognition that maybe the business and the human rights architecture, relying primarily, if not only, on states doing what they are meant to be doing, that there was maybe a gap because states weren't always doing it. For whatever reason, ability, willingness, maybe states thought, well, we need to attract investment, so we can't also put in pesky regulation, then the companies will go to our neighbor country next door, and this whole race to the bottom thing, or whatever the reasons. There was a problem because increasingly there was an awareness that people were sometimes being harmed in the context of business activities. Again, this is not to say that business is bad or business is all bad. It was just increasing civil society organizations, human rights organizations, media releases, that there were just some problems. We had Nike, the US brand, who had outsourced their production of their sneakers and their t-shirts to factories in Asia. And it became increasingly well documented that in those factories, there were a number of children working. So there was campaigns against Nike and there was the famous Just Do It, where you see a drawing of a little girl sitting in front of a sewing machine. It was that increasingly public awareness that by changing their production patterns, companies actually were involved with human rights issues, and states were not always willing and able to do what they meant to be doing. So the responses to that from the human rights world and from companies was to start with some voluntary initiatives. So we had from the UN side the UN Global Compact, which was launched in the year 2000 by the Secretary General of the United Nations at the time, Kofi Annan, which invited companies to sign up to a compact, a global compact, where companies would commit to respecting international standards on human rights, on labor rights, on environmental rights, and later on anti-corruption. So that was one approach, that companies would themselves voluntarily commit. From the UN human rights system side, at the international level, there were some attempts also in the 1990s and early 2000s to draft a new treaty on business and human rights, a treaty-like document. Again, there was this recognition that maybe the human rights architecture being focused only on states, there was a gap that needed to be filled in that architecture. And because international human rights law is a legal system, the response was initially to say we need a new legal treaty that will plug this gap, that will bridge this hole. There were a number of, within the human rights, we call them human rights mechanisms, so different UN-appointed experts on different human rights issues, and treaty bodies, we call them human rights treaty bodies, expert bodies that have been appointed as part of the different human rights treaties. That's a whole other thing for another day. But these human rights mechanisms were increasingly beginning to say, yeah, companies really should be doing this or they should be doing that. But there wasn't a very clear normative underpinning or coherence between these different initiatives at the international human rights level. Business, many companies individually came together also in industry associations were trying to do corporate audits or come up with their own voluntary standards for a particular sector. But what was clear from all of these different attempts to bridge this gap was that they were mainly voluntary. This attempt to, that is on the slide, to draft these norms of the responsibilities of transnational corporations didn't get political support. Member states didn't want this treaty. And the UN Global Compact, the industry initiatives, the CSR wave, it was all companies themselves. When they did it, they would say, well, this is what we think we should be doing, or here is what we would like to focus on. So it was very ad hoc, very limited, not systemic, and by and large voluntary, and there was no effective oversight of whether companies were doing what they were doing, because again, there wasn't any sort of combining, unifying foundation on which to assess whether companies indeed were doing what they were meant to be doing, or whether what they said they were doing was the right thing that would get to the problem in terms of harm on people, in terms of adverse impact on human rights. And when you ask, at the time, there was no agreement. So governments would say, well, human rights, that's for us, and we're doing what we're meant to be doing, and if not, well, we're states and we're sovereign, and if you tell us anything else, then you're interfering with our sovereignty. Companies on their side, they would say, we're not against human rights, but human rights have nothing to do with us, because they are for states, and we are companies, and our job is to do our business in a way where we adhere to all national laws, all standards that apply to us. If there are no standards, or if they are not enforced by governments, that's really not our problem, because we only have duties under laws that exist, and human rights law doesn't apply to us, and if states are not enforcing their human rights obligation through effective regulation, that's too bad. But it's not because we don't like human rights, it's just that they are not our responsibility. Except when we decide through our CSR framework to do something that we think makes sense to us. So that was really the situation. So a very, have I already spoken to this slide now? Sorry, I haven't given this presentation for a while. So
That's okay.
So maybe I'm getting ahead of myself, yeah? Focus on states, that slide was totally repetitive. So, so we're now at 2005, and there's been all these initiatives and very heated and very, very polarized discussions between human rights advocates and business. Human rights advocates saying, well, because business can impact human rights, they have the same duties and obligations of states. You heard earlier what I mentioned what companies' position was, so there was just really no meeting of any mind. And governments, again, insisted that they were the primary holders, but they were also under increasing pressure to say, yeah, there might actually be something we need to look at here. And this was at a time when we were then, as I said, in the early 2000s, 2005, where the old sort of traditional divides in geopolitical divides, so traditionally it would be human rights terms, there would be the old Eastern Bloc, so those that were aligned with the Soviet Union during the Cold War, they would say, well, we like human rights, but only some human rights, the economic, social, and cultural rights. Then there would be the sort of Western countries and those that were aligned who say, well, human rights are really about civil and political rights and freedom of expression and right to fair trial. Those are the things that we care about. So those were the traditional divisions. And then the rest of the world sort of followed whatever their geopolitical alignment was. But by early 2000, the world was quite a different place. The Cold War had ended, at least at the time. And there was a much more south to south economic activity. China was rising, going into different parts of Asia, into parts of Africa. So the whole developing country, north, south, east, west, it was becoming just a lot less clear. So when states said, well, we still want to be part of human rights because it's really our system, but maybe we need someone to look at this because we see there is a problem, we can no longer ignore it, but we need someone in a way to take it over from us. So they outsourced it by asking the Human Rights Council, which is the UN member states that sit or represented on the Human Rights Council. They said, okay, we need someone to sort this out, and they asked the Secretary General to appoint John Ruggie as a special representative on this issue, just basically to sort it out, to clarify what is up and down in this, what are the gaps, what does it mean for states if companies have responsibilities, what does it mean for us as states. So that was the broad mandate, but in a deeply, deeply polarized and very, very fragmented world when it came to thinking about what is the responsibility, the expectations of business when it comes to human rights. So John Ruggie was appointed in 2005, and he spent 3 years looking at this, consulting with many, many people in all parts of the world, researching, etc., etc. And after 3 years, he presented what he called the Protect, Respect, Remedy framework. And that was really quite astonishing, and I'm saying this as someone who's worked at the UN for many, many years, that after 3 years, coming from this extremely fragmented, polarized situation, in 2008, there was unanimous consensus from member states in the Human Rights Council saying, yeah, we like this. This is the right basis on which to think about this. The states, business, human rights, people that are impacted. How do we think about it? The Protect, Respect, Remedy framework. And the Human Rights Council said, we like this framework. It was sort of an approach. Please spend another 3 years to operationalize it. So the whatever. In 2011, in response to the second mandate, John Ruggie presented what we now know as the UN Guiding Principles on Business and Human Rights, which the official name is the Guiding Principles to Operationalize the Protect, Respect and Remedy Framework. So that's the full name because it really is what it was, but essentially we all now universally refer to it as the UN Guiding Principles on Business and Human Rights, the UNGPs for short. And so John Ruggie, when he presented in 2011 the guiding principles to the Human Rights Council, and the picture there in the back is the council room. I don't know if any of you have been on a tour of the Palais des Nations, but room 20 is the council room with this quite distinct ceiling. So he sat in room 20 and said, we now present you the UN Guiding Principles, but we're just at the end of the beginning. And what did he mean by that? He meant now for the first time, there was an agreed normative foundation to think about business and human rights. The whole 6 years of, and I mean, I was there with him for the 6 years, we did a lot of work for those 6 years, and you think, oh God, we're only now at the end of the beginning. My goodness, that was a long and very busy beginning. But what he meant was, the beginning was to even have a basis on which to start working on this. Because beforehand, it was all over the map. There was no agreement, there was no nothing. By having now an agreed normative framework that everyone could then, if you say, well, you are not doing what you're meant to be doing, it would be anchored in something. And if you were accused of doing something, you can say, well, yes, I have done this, or no, you're right, I haven't done that. But it was, instead of having constantly moving goalposts and speaking past each other, now there was actually an opportunity to make the cumulative progress and get that transformational change in terms of what the role of companies are when it comes to human rights. They were unanimously endorsed by the Human Rights Council, and again, from after 6 years, that's pretty quick in UN terms to get going from really -0 to 100%. Also endorsed by global business organizations, most civil society organizations. Some were a little bit skeptical, would have liked to have something that looked stronger. National human rights institutions and trade unions. So really all the key stakeholders were saying, okay, now we have this. It doesn't mean that some didn't want to have something more or something different, but at least now there was this agreed framework. And with the endorsement of the guiding principles in the Council, it really provides you with a very strong global political foundation and authority. So it's not a treaty, it's not a document that is open for ratification, where states can go and ratify and do what they do when it's a treaty. But it's a document that builds on existing legal obligations that states have and put quite clear provisions on what states have to do in relation to companies. John Ruggie himself said that his approach from day one to his mandate was to one of principled pragmatism. So it's based in principles, it's based in human rights standards and norms and principles, but the way it is framed and the way to go about achieving it requires a level of pragmatism in order to get things done. And it's structured around the 3 pillars: protect, respect, and remedy pillars. And here they are. So what he did in the guiding principles, first in the protect, respect, and remedy framework, that then became the 3 pillars of the guiding principles, is to distinguish between the roles of and duties of governments and companies. So the first pillar is the one that is addressed to states. And that is taken on and quotes from and is anchored explicitly in existing human rights obligations that states have already undertaken since 1948, the Universal Declaration, on what you have to do as a state to protect against harm by one private actor, company, against another private actor, an individual or a community. the state duty to protect is already a deeply entrenched and well-anchored principle of existing international human rights law. And the first pillar of the guiding principles elaborates on what does that mean specifically when it comes to protecting against business. What are the appropriate policies and regulation and policy domains that states need to look at where this duty to protect against human rights abuses by companies needs to sit or needs to be reflected. And when we're thinking about business and human rights, it covers so many areas of policies and law. So it's not about having one business and human rights law, it's about making sure that when you are doing consumer protection laws, for example, that the rights perspective is well reflected. It doesn't mean that consumer protection law becomes a human rights law, but the duty to protect needs to sit in that. If you're talking corporate law is governing how companies have to operate. That's not a human rights law, and no one says it should ever be. But it needs to be structured in a way that it means that companies can and should be operating with respect for human rights as it goes about doing whatever it's doing in whatever sector and operational context it is. So again, it's the first pillar, it's about the states, and it's where are the areas where states need to think about making sure that human rights can be protected. Also, for example, you privatize a utility, electricity, for example. That's human rights law, I would still argue, some people disagree, but doesn't have an opinion about whether electricity comes to your house and to your grid through a public provider, public utility, or privatized. When I grew up, it was all public. This is now many years ago. Nowadays, in most countries, this comes through, and also depending on sort of different national cultural traditions, is now done by private companies that provide the electricity. Human rights law doesn't have an opinion about that, but it does have an opinion about if a private company decides to have a pricing system that means that the core provision of electricity as a core enabler of people living a life of health and dignity and warmth, if they are excluded either because of they belong to a particular community that are marginalized and subject to discrimination, that's when the state duty to protect. State need to make sure that as they are outsourcing delivery of these services that are essential to the enjoyment of human rights, that a private company doesn't discriminate or doesn't impose practices that impose unduly burden on some or excludes one community of others. So all that is covered in the first pillar of the guiding principles. So a distinct but complementary pillar, the second pillar, is the one that is addressed directly to business. So that was in a way the new kid in town, you could say. That was the one that speaks directly to what it is companies have to do. Pillar one is basically elaborating on existing human rights law. This one recognizes that states and companies are not the same. They're not the same kind of social actors. They don't have the same amount of democratic legitimacy. If you're lucky enough to live in a democratic society where the government is accountable to the people, companies are accountable to their shareholders, to their, whoever is regulating them. But this is the one that introduces a distinct and new responsibility on companies to also have a responsibility to respect human rights. I can go in and happy to answer questions on how and why that was the standard of responsibility that was developed, but suffice to say that it reflected, all these 6 years of consultations, but also reflected a number of declarations that companies themselves were doing, saying they would say, on their website, they would say, we respect the Universal Declaration of Human Rights, for example. It also reflects, we did a study of about 350 allegations made against companies from different sectors and different parts of the world, and essentially set out based on that saying, okay, what are what are the complaints that sort of communities, society has against companies, it's largely anchored in that they are infringing on people's rights. So we sort of put together from different entry points something that reflects what is the core expectation that society has. Doesn't mean that it's only anchored in social expectations, but what is essentially the core expectation is that companies go about doing their business in a way that do not harm people. That's what the core expectation of society is. So the second pillar reflects that and sets out the core responsibility to respect human rights through and meaning acting with due diligence to avoid infringing on the rights of others. So doing no harm, but knowing and showing, being able to show that you don't do harm to people through having effective internal processes in your company. Because if at the time, we would ask a company, so how are you in human rights? And we were absolutely fine, we respect the Universal Declaration, we've got it. And generally would ask, well, how do you know that you do that? Oh, well, because we made a commitment on our website and it says that we respect, but how do you actually know? Have you assessed what your risk could be to human rights? And do you have processes in place that you could respond to and mitigate those risks? And the answer, of course, would be no, because that wasn't on anyone's radar screen. And again, not to say that companies didn't care, it just wasn't on the sort of, in anyone's KPIs, it wasn't on anything other than this was maybe the public affairs people who would do, or the CSR department or whatever, but really that embedding of this responsibility as another risk to be managed, just like a company needs to manage a number of other risks that no one will really question. This was about, well, are you managing your risk to people? And how do you know, and are you able to demonstrate that you have taken effective measures to prevent and mitigate the risks that you're having? And those risks will be different from company to company, because it depends on where you operate, what your sector is. Oil companies' risks are different from the pharmaceutical companies. And so it was really about, and the second pillar is about stipulating all these types of internal things that companies need to be able to have in place in order to assess and respond to their distinct human rights risks. And finally, the access to remedy. Why are we talking about human rights and why are we talking about business and human rights? Because there's a people there. It's about humans. It's about, and now also about the human right to a healthy environment. And what was the biggest driver of protest against companies, that was driving for example, the anti-Nike campaign and the others? It was that people were not only harmed, but they had no way to go, basically, to get a remedy or to even raise a grievance. So the third and equal pillar of the guiding principles is about where are the places, what are the systems that need to be in place, so where harm happens. And even with the best of prevention efforts, no one can guarantee that systems will fail, let alone all the ones who are not even making an effort. So what are the systems? Judicial, courts is one option. Courts are largely inaccessible, have been largely inaccessible to communities that have been affected by large-scale mining or dam building or whatever, where they haven't been properly consulted and where their rights have been infringed. Non-judicial mechanisms, complaints, labor inspectorates, consumer protection ombudsman function, all these sort of state-based non-judicial. So instead of going to the court, you are complaining if you get hurt by your whatever product that you have, you want to take it somewhere because you want to get, if you've been harmed or in any other way impacted, you need to be able to get redress. And then finally, what are the institutions and mechanisms inside a company where people could go? Most human rights issues don't arise to a big international court case. Many of them are relatively minor grievances that, if not addressed, can escalate and become big human rights issues. So Pillar 3 looks at what should be in place, effective mechanisms that, depending on the case that you have, if you want to bring a case against the company, doesn't mean that you will always win, but you need to have credible and effective mechanisms, either judicial, state-based, non-judicial, or operational level grievance mechanisms, that at least you have your day, if not in court always, but at least you have a chance to get your claim assessed. And that is the sort of three, and they're all, again, states are not the same as companies, and remedy belongs both to states and to companies when it comes to responsibilities. So I've already gone through most of it, but just a couple of key features. The guiding principles is a policy soft law document, we call it, and it just applies to all. It says it's all states. Never mind what you have ratified. Have you ratified 3 conventions or 9 conventions? It doesn't really matter. What the guiding principle said. It says you either have legal obligations or there are very strong policy reasons for you to do what Pillar 1 asked you to do. So don't come to us with, oh, but I only ratified, this one, and that didn't say what you're saying. It's like, just get on with it. There is no principled base on which one can say for some states that, you should be doing this. The same with companies. All companies of all sizes in every sector and in any country. That's quite a lot. And if you think of the, Apple or Google versus, a small enterprise in somewhere in Switzerland, they are not the same. And their human rights risks are not the same. But the processes whereby they need to look for what their human rights risks actually comprise very similar processes. Not the scale, not the questions you're asking your stakeholders, but there's no principled basis on which one can say that if you are a company with, let's say, less than 50 employees, it's okay for you to abuse human rights. What basis could one say that on? I don't know. So we said, okay, it's easier, it applies to everyone, but obviously how you do it will, and the scale on which you're doing it, will depend on your size, your sector, where you're operating. If you go to, the Democratic Republic of Congo or sort of other high-risk areas, you would have to ask some different questions than if you're doing the exact same business in Switzerland, because the context is just very different. And you need, as a company, to understand that. So, distinct but complementary, no new legal obligations. As I said, it's not a treaty, but it is anchored in legal obligations that states have, and it, as part of those legal obligations, is for states to put in place effective regulation and policy. So where there are legal developments, it creates the guiding principles. Where there are legal developments as a result of the guiding principles, it means that the guiding principles has legal effect, but it doesn't mean that the source of the law itself is in the guiding principles. I think that's probably it. Here's another slide, and I'm very happy to share the slides, so you can, but it's like the why question. Yeah. And it's, as human rights people, we would think, oh, but why? Because it's the right thing to do when human rights are good. And depending on the audience, it's nice to have a few more sort of tools in your box when you ask the why question. Why should companies respect human rights? I just think it's important to understand that when one is using these other arguments, so it can lead to increased risk, reputational risk, it's the expectation, it may not be the same for every company. So there can be companies who will say, well, we can happily operate with absolutely no respect for human rights, and because we are either an unlisted company, we are not subject to any reporting requirements, we are operating in a jurisdiction where legal system and enforcement doesn't exist, so, this is not, we are in fact benefiting from lack of human rights. So if we come with them and say, oh, it can be a risk to your business, then they say, well, no. And so if that's all you have it on, or the reputational risk, many companies, not most companies, they don't have any public reputation to protect. They are business to business, no one knows who they are. And so again, just on the business case, the why question, it can depend on what company you are and where you are, and what your risk may be. So yeah, there's been since 2011, there's obviously been a lot of developments. Is the glass half full, half empty? Has there been enough? There should be a lot more, let's just say. The job is very much not done, but I think one can certainly make glasses half full by saying that since 2011, there has been an enormous amount of regulatory initiative launched. There has been an enormous amount of companies who actually are looking at this and trying to implement it. But of course, there's been many more who don't even know this exists. So there's still an enormous challenge. What has happened since 2011 is, I think, the more significant of the developments have been around technology and the role of digital technology. It was a little bit there back in 2011, but it's obviously today, if we were doing the guiding principles today, then that would be a bigger feature, but it doesn't mean that the guiding principles don't apply to tech, and in fact we have a big project called the BTech project, the Business in Human Rights and Technology, that looks at applying the aims of the guiding principles to tech, which can absolutely be done. So we don't need all these new standards that people are calling for, because we actually do have standards already, and we don't have time to wait for new standards to be delivered. It's about making sure that they are applied and that they are elaborated on in a way that addresses specific risks from a specific technology, rather than reinventing the underlying and fundamental human rights responsibilities and risk mitigation standards. So I mentioned, and I'll just end with this, that there's been a lot of regulatory initiatives that have happened. Most of them since 2011. The observant one will note that the first one, the California Supply Chain Act, Transparency in Supply Chains Act, is from 2010, but also reflects already the protect, respect, remedy framework and the notion of due diligence, human rights due diligence, doing due diligence to avoid and being able to be transparent about what you find has happened. In Europe, there has been the French duty of vigilance law, which essentially, in key aspects, not entirely, but in key aspects, impose on French companies a duty to undertake human rights due diligence to understand your risk, and then it's a little bit different, but it's the essential core is that companies need to have a plan for how they address their human rights through their supply chain. There's also a recent but quite far-reaching German law on companies of a certain size, German companies needing to identify human rights risks in their supply chains. And then we have an EU-wide initiative, which has been going on, but which now might sadly fail. But this EU-wide initiative was there in response to all the different legal initiatives that had been springing up since 2011, and it just ended up being, or a risk of being, very ad hoc and on level playing field. If every country has its own standards, even if they say that it's based on the guiding principles, but it's all a little bit different, and is it really based on the guiding principles, etc. So companies were complaining to say, well, we're now having all these different regulatory initiatives to respond to. We need, they didn't say we need something more, but they were complaining. So the European Commission launched an initiative for an EU-wide directive on corporate sustainability due diligence. So that would basically mandate across the 27 EU member states due diligence in relation to human rights and environmental impact. And a lot of work has gone in over the last 4 years, and last week it failed to get the necessary votes in the European Council, so European member states. The European Parliament have a proposal that was agreed in December. There was a compromise text, so everyone assumed that this vote last week was just like confirming what has already been agreed in December. And so now it has to be adopted, and bizarrely, some key countries, including Germany, who have their own law, and who initiated this thing when they were president, had the presidency of the European Council 4 years ago, they abstained, because now politically in Germany this is no longer. So it makes there's no rhyme or reason. A big fault line is the frankly grotesque business lobbying that has been taking place in Brussels, which has just mischaracterized this initiative tremendously. So it's actually really, really depressing. But anyway, we are still optimistic that something will come out of it. But in any event, the agenda is big enough. It can't be stopped, even if this EU thing is a setback. All right. I think if I'm going to have time for questions.
I'm afraid we're actually out of time.
We're out of time. Oh my God. Sorry, I've just been going on.
But thanks first. This was fantastic. Really, thank you.